UAE is home to a wide range of nationalities. Living in the UAE is an experience like no other. We have been receiving quite a lot of inquiries recently on rental disputes. So today, our Senior Associate Shehab Mamdouh will be answering few of the frequently asked questions. How can the landlord or tenant modify the payment or contract terms?
The tenancy agreement is a normal contract, such as any contract. So if the parties agreed mutually on the terms and the conditions of the price of the rent, of the time of the rent, time frame for the lease agreement, then there is no problem. If they did not reach an agreement, then the rent committee, which is the concerned authority to identify or to determine who's right and who's wrong, they have a specific system to decide on that, which is the RERA calculation or RERA calculator, which is well speculated in the as per each area, which like we'll give an example, like area like Business Bay here. There are average of rent, and then they will take with this average price of rent, and then it will be applicable on both parties, the tenant and the landlord.
Can the landlord terminate the contract before the tenancy period?
With regards to termination of the contract, as we said in the previous question, it's a normal contract. As long as the parties agree to terminate, there is no problem or no issues. The issues will come here when any of the parties want to terminate the contract and the other party doesn't want to. So for the landlord or the tenant to terminate the contract, the law has specifically put some regulations to regulate such actions. If the landlord wants to terminate the contract before the tenancy agreement ends, there must be a violation to the contract with regards to the rent not paid or subleasing the property. In that situation, the landlord has to notify the tenant at least a month in advance that he's going to terminate if the landlord didn't comply. If the tenant didn't comply with the landlord's request, then the landlord has the right to terminate the contract, but the contract does not terminate by itself or just by notice. A case has to be filed before the rent committee for termination of the contract. The other part of terminating the contract is terminating the contract after the tenancy agreement, which means at the end of the tenancy agreement. In this situation, the landlord has to notify the tenant prior to the termination of the contract at least 12 months in advance, which is 1 year. If the landlord didn't do that, then the contract cannot be terminated by law or by the court.
Landlord terminated contract and refused to return the deposit.
With regards to security deposit is basically paid by the tenant to the landlord to cover any problem or any damage that happened to the property during the lease agreement. Therefore, the landlord has to keep it until the end of the tenancy agreement. Once the tenancy agreement is finalized, the general practice, the landlord will bring the maintenance companies or whatever, just to check what's need to be fixed, what's need to be replaced, and then to be deducted from the tenancy agreement. If there is any difference payable to the tenant and the landlord didn't pay it, then the tenant has only one option, is to file a case before the rent committee to recover the remaining amount.
How can a person file a rental lawsuit and where?
With regarding to initiating a rental lawsuit or a rental dispute or a rental case, the concerned department to review such cases is Rent Dispute Resolution Center, which is located in Dubai beside the Land Department. The process of registering the case or filing the case online, that you have to file it either through your lawyer. They have their own system to register the case. Otherwise, there are some offices provided by the government where they can assist you to register your case online, and then once the case is registered, it's a normal litigation proceedings where parties has to be notified and then appear before the judges in the scheduled hearing, and then the case will go on.
Can the landlord evict the tenant for subletting the premises?
One of the things where the landlord can request the tenant to vacate the property is for subleasing the property without a written agreement between the landlord and the tenant. So if the tenant violated that, the landlord has a right to terminate the rent or the lease agreement, and has to notify the tenant through the public notary and then file a lawsuit for eviction.
So there's a very interesting inquiry we received lately. A person said he had given a lease amount to an agent to stay in a hotel apartment, and the agent now ran away with everybody's money and they did not pay anything to the hotel as well. Now the hotel apartment is asking the people to leave the hotel or pay for the next 6 months. Otherwise, they would end up in court. They are also not disclosing the contract that they have between the hotel and the agent. What can a person do in this kind of situation?
With this particular inquiry, if the tenant has already paid the rent for 1 year, then simply the hotel apartment management cannot just evacuate him and request him to leave or to pay. Because if the tenant proves that he has paid the full rent amount for the period that he's staying over there, it doesn't matter to whom he paid the money, either to the agent or to the hotel apartment directly. Therefore, if he submits that before the rent committee, then they cannot let him evacuate, and he will remain. And when it comes to renewing the yearly contract, it is subject to the terms and the condition of the contract itself, so it's case-by-case basis. But simply, no, they cannot if the tenant proves that he has paid the full rent amount.